Okay. Sit.
Okay. For the fact of the case, for this case, Zainal Zakaria actually was one of the solicitor for Anwar Ibrahim in his trials case, and he was found contempt during the trial. So actually, Zainal Zakaria filed a motion before the court for the two senior prosecutors to be prevented, prohibited, or discharged in order to further prosecuting the case, as it and also the conduct have been referred to the AG for the appropriate action. However, his act was found contemptuous. So actually, the motion that has been filed by Zainul Zakaria actually supported by affidavit based on statutory declaration of Manzit Singilon, and it said that um, the two prosecutor had asked Manzit Singilon to fabricate the evidence. So the High Court judge struck off the motion that was filed by Zainul Zakaria, and similarly on the basis of its being contemptuous. So High Court sentenced to 3 months imprisonment for filing the notice of motion, and also
Who's
Court of
the
Appeal
judge?
also affirmed the decision of the High Courts.
Who was the
And
judge?
yeah,
Who was
for
the
the
judge?
for the judge, for the High Court judge and also the Court of Appeal judge affirm the decision of High Courts. But
Siapa
at
nama
the federal
hakim tu?
level,
Hakim mahkamah tu siapa namanya?
in is a Steve Chief Judge in Sabah and Sarawak,
Hmm?
um, in the High Court judge.
Ada berapa orang High Court judge? Tengok balik siapa High Court judge. Sebab ini kan question on contempt. You should actually have information on siapa the judge that cited him for contempt. And the different level of the court, kalau boleh nak tahu siapa judge tu. Kadang-kadang kenapa ya, sebab judge yang sama you can see the trend, dia suka cite lawyers for contempt. Ada macam consistent record ya. Kalau boleh tahu nama. Okay, nanti bagi tahu sekejap lagi. Proceed dulu.
Okay. So the federal court decided that the High Court judge had incorrectly applied the summary procedure, resulting in injustice to Zainur, as Zainur Zakaria had not given opportunity to defend himself, on as he was found contempt during that time.
So in this case, the summary procedure was adopted. That means he was not called to enter defense. Yeah? Summary procedure is for cases in which the judge feels that it can be speedily disposed of. Okay, dalam keadaan di mana evidence is very clear and the person against which the claim is made has no defense. Normally, they don't go by way of calling for the defense. Okay, it's just between the judge and maybe the prosecutor. Okay, and it's summarily decided. So he was not given the opportunity to defend himself. This is one of the areas in which the law on contempt is found to be problematic. Yeah, we do not have a clear set of procedures on how cases of involving contempt of court are to be conducted, right? With uh, with you know equal opportunity to defend yourself given to all parties lah, right? So this is one area in which I think reform is needed in the context of our law uh, on contempt. Yeah? Next.
Okay, next, the issue of the case, whether the Court of Appeal had in law as the filing of application by the appellant to disqualify the two senior prosecutors was reckless and act of bad faith, which constitute abuse of the process of the court, and B, whether the Court of Appeal has in law when holding the decision by the High Court, which had adopted the summary procedure in convicting the appellant of contempt of the court. So we go through the principle of the case. In the case of ballot against Crown Court at St. Albans 1974 for the judge Lord Dennings. So in this case, for the powers of summary punishment, uh, need has actually the court has the power to punish everyone. However, it is necessary to limit or to maintain the dignity and the authority of the judge as to ensure that everyone has the chance or opportunity to have a fair trial. And also the second one, um, it is to be exercised by the judge by on his of his own motion only when it urgent or when there is emergency cases, or to act immediately in order to prevent disorder and also to ensure or enable the witnesses to be free from fear and jurors from being improperly influences. And the second cases that have been applied in this case is Jaginder Singh and others against AG 1983, where actually it is used for the summary contempt procedure, which is not only should be employed more sparingly, meaning to say it cannot be frequently used, but it should be used for the exceptional cases where it is in order to preserve the integrity. It's just the same with the first principle in the Balak against Crown Court. We have to maintain the dignity of the authority and of the judge. For the rules in the legal profession, practice and ethic, 1978, for rules 9 and rules 16, where in the first, the rules 9 states that advocate and solicitor who undertakes the defense of a person in any criminal matter shall present every defense with fair and honorable. Meaning to say that Zainul Zakaria, as advocate and solicitor for his client Anwar Ibrahim, has the right to defend his client by filing the motion in order to make there is no abuse of the abuse of the unfair treatment for his client. And the second, for the rule 16, states that an advocate and solicitor shall act with courtesy to the tribunal and need to uphold interests of client, justice and dignity or profession. Okay, that is the principle of the case. And then for the judgment of the case, the judgment, okay, there
We
is
have to be clear when you talk about the judgment. I hope you can go by the level of the court. The first was High Court, and then Court of Appeal, and then Federal Court, and then only later you deal with the principle. Okay, principle, kalau boleh principle expounded by the highest court lah.
Hmm. For the judgment of the case, in the federal court, chief judge Sabah and Sarawak. Okay, the first stated that the appellant had prima facie justified in filing the said application, therefore there could not be abuse of the process of the court. Second one, the learned High Court judge should have allowed the appellant the adjustment. Adjustment means you said for requesting
Adjournment, to adjourn into postpone, right?
postpone or delay the so that he could prepare his defense fully, fairly, and effectively. So, so the solicitor then appealed to the federal court, and the federal court, per Haida federal court judge, is this conclude that, in my view, he was prima facie justified in filing the said application, which to say that he agrees on the statement made by the chief judge. So, not only was the accused deprived of a right of full hearing on the matter that he had complained about, but his solicitor could no longer continue to act for the accused as he blocked from or depriving him of his constitutional rights to the legal professional of his choice by based on the Article 5, Clause 3 of the Federal Constitution. As we all know that everyone has their own right to have.
Okay, can you please go back to the question, the first slide?
Slide on the analysis.
Okay, what about answering is threatening a advocate and solicitor with contempt necessary based
On
on
the
its, what is the type of contempt? Is it civil in this case? Is it criminal? You have to go back to the law on contempt. You have to identify what is the type of contempt and what is the rationale behind allowing for lawyers to be, charged for contempt. What is the rationale, and to what extent, can a lawyer exercise his duties towards the clients? Okay, when it borders contempt, how do you determine whether he has gone beyond the limit? He has acted beyond good faith, or he has been motivated by his personal feelings, for instance, against the judge. So you have to understand the law in entirety. Ya. That means you have to tengok ini adalah keadaan contempt yang macam mana. Is it civil? Is it criminal contempt? Okay. Is it slandering the judge? Or what types of contempt is this? And apa considerations that you have to apply, okay, in order for you to determine whether contempt has been committed or not. So by understanding these two concepts, yeah, then you will be able to answer the first question here. Is threatening advocate and solicitor with contempt necessary? You appreciate the context that I mentioned. So apa pandangan you mengenai question, is it necessary? Ahli-ahli you, ahli-ahli mana? Boleh tak jawab soalan yang pertama tu, sebab soalannya bertanya, is it necessary or not discussed in the light? You have not come to that part where you have to answer is it necessary or not. You have to apply your own analysis. What is the purpose of contempt? The law on contempt. Anybody from
Hello.
here?
So, the law of contempt is used to hold various parties, especially lawyers, who act as an officer of the court, to be accountable in a case for improper conduct to protect the administration of justice.
Okay, to protect the administration of justice. Alright, to ensure that people have respect and confidence in the administration of justice. Okay, to not obstruct the the process of court. Okay, those are among the reasons why we have the law of contempt. Okay, not to disrupt proceedings. Okay, trials and whatnot, and not to actually simply uh, ridicule a judge and attack the judge personally, ya. So itu adalah antara reasons why you have contempt of court, ya. So in other words, this is the rights of the public to ensure that the administration of justice is not obstructed or prevented. So is this a criminal contempt or a civil contempt? What is the difference between a criminal contempt and civil contempt? Okay, what is the nature of a criminal contempt? Anybody? Senyap je macam tak revise ke lesson yang lama ni. Please contribute to the discussion. Yeah? What is the difference between criminal and civil contempt? If you take the example of the case of Zainul Zakaria just now, which category does it fall into? Does it fall under? Is it contempt in the face of the court? Something that the contemptor does with which immediately disrupts or interferes with the proceeding, and something that leaves the judge with no option, okay, but to fine or to sentence the person.
Criminal contempt.
Criminal,
Or
criminal contempt.
is it civil contempt? What's the difference in essence?
Civil contempt to happen when a person refuses to comply dengan court order.
What is it that criminal contempt has and civil contempt does not have in terms of its nature? So criminal contempt, there are several types, okay, such as scandalizing the court, okay, interfering with the course of justice, prejudicing or impeding court proceedings, and contempt in the face of the court. Okay, the nature of all these types is that it has something which you call public wrong. Okay, it affects the interest of the public in the administration of justice, yeah, as opposed to the lesser degree of civil contempt, yeah. Interference with the course of justice. Kalau you tengok artikel 126, okay, the power of contempt is the federal court, the court of appeal and high court shall have power to punish contempt of itself, right? So ini memang ada dalam Federal Constitution, and it actually conflicts with something that you are familiar with, yeah, freedom of expression, right? Freedom of expression adalah a fundamental right of everyone. Okay, how would you in a way between the right not to interfere in the administration of justice and your right to exercise your duty as a lawyer and to express your freedom of speech. Okay, these are the three areas in which contempt is discussed together. So there are tensions between these three areas. So when you discuss the question just now, is it necessary to apa dia? Can you go back to the first slide tadi? Is it necessary to threaten, right? Lawyers with contempt? You have to appreciate all these concepts, okay? The rationale why contempt is needed and how in principle it has been abused, what is missing in the law, okay? So all these are needed for you to answer. Is threatening A and S, advocate and solicitor with contempt necessary? So you have to know and appreciate why contempt is needed if you do not actually use or if the judge in question simply resorts to punish an advocate and solicitor uh, with the intent of protecting his own reputation as opposed to, protecting the administration of justice, would this contempt law be justified? It wouldn't be justified. So what are the boundaries? Okay, so you have to understand the concepts in order to, identify the boundaries. Okay, setakat mana contempt of law should be used so that it doesn't get to be easily abused by those oversensitive judges, for instance. Yeah, sikit-sikit nak apply contempt. So ini memerlukan you memahami konsep, ya, konsep dan juga konteks, boundaries, okay, as well as the experiences of advocates and solicitors through case laws. So what happened in Tommy Thomas?
Doctor,
So,
Yeah,
for boundaries too, it depends on each case, eh?
yeah,
It-
it can be. We don't have a statutory law yet. I think the AG is looking through a bill, okay,
I
which
see.
is forwarded by, I think, prepared by the Bar Council, if I'm not mistaken. So we do not have a clear statutory law to govern the conduct of this contempt. The procedures and the law very much depend on common law. Okay, so you kena
Okay.
baca case law, terutamanya mungkin English law, tapi tak semestinya English law will be straight away applicable because we have a different context, the nature of our system might not be exactly the same. So we have to be careful as well when we want to import cases into our system, yeah. Right. So
Okay.
kena appreciate kenapa ada contempt of law. What is the purpose? Okay, public interest ke interest of the judges, alright? Setakat mana you boleh tengok benda tu sebagai abuse ataupun sebagai protecting the public interest to have faith in the administration of justice.
Okay. Got it.
So saya tidak adalah satu-satu jawapannya, but bila you you membaca dan cuba menjawab soalan tadi, memang you kena faham konsep dia dan limitnya. Okay, boleh teruskan dengan MBF Capital.
Assalamualaikum and good evening. In MBF Capital Berhad and another, and Tommy Thomas and another, 1999, this case illustrates on contempt where there is disobedience to court order. The defendant, Tommy Thomas, who is an advocate and solicitor, had made remarks on an article in a published legal journal accusing the lawyer for the plaintiff in one case had improperly seeking to obtain favors from the judges concerned in the litigation they were involved. So the plaintiff then initiate a defamation actions against the defendant for his said remarks in the article. Just before the trial, the party had negotiated and come to a settlement, and the term of the settlement are to be read in open court. The term of the settlement is that the defendant accept that the plaintiff was not guilty in obtaining the special favors of the judges in the litigation as described in the article, and apologies to the plaintiff. The defendant also pledged in the court that he will not repeat nor publish the said words in the article and pay damages to the plaintiff. However, the defendant faxed a message to 3 daily newspaper contending that the settlement was made against his wish and was insisted by the plaintiff, although he retracted the statement later. The court then issued a notice to the defendant to show cause on why he should not be subjected for contempt. At the hearing of the notice to show cause, the defendant did not object the said notice, but he only want to mitigate. He filed an affidavit tendering an unconditional apology to the court, and the defendant's counsel submit that there is a trend not to impose a custodial sentence when an apology has been tendered immediately. So the issue of the case, first, whether the defendant should be cited for contempt, and second, whether the defendant should be given custodial sentence. As for the judgment of the court finds the defendant guilty for contempt and sentencing him to 6 months imprisonment on several grounds. First, D act with dishonesty to the court where he failed to come clean. His explanation to press statement that the action was settled despite his express objection was meant for the plaintiff only, did not have any merit. And the judge finding is that Mr. Tommy Thomas intend to portray as a whole that he was never a willing party to the settlement. And next, since Mr. Tommy Thomas was not challenging the notice to show cause and indicate his intention to only mitigate, he was guilty of the offence of issuing a press statement in breach of court order after he had authorized the reading of statement in open court by his counsel. Next, the defendant should have refrained himself from making any press statement without first consulting with his solicitor. His insistence in conveying his opposition to any settlement to the insurers only was a clear indication that he was not completely remorseful. This was a clear case where a custodial sentence was necessary. As for the principle of the case, the judge referred to the Federal Court in Trustees of Leong San Tong Kong, Konsi, P9 Register and others, and SM Idris and another application in 1990. Mr. Murthy, a senior advocate and a solicitor, has been cited for contempt and has been imposed a custodial sentence upon him by the judge to a day's imprisonment and 50,000 ringgit as fine in default 6 months imprisonment. And next, judge also refer on the case of Anthony Ratus, son of Domingos Ratus and City Specialist Center, 1996. The same advocate and solicitor was charged for contempt, for a third contempt, and where the learned judge imposed only a fine of 10,000 ringgit in default 3 months imprisonment. This was because Mr. Multi had, upon being served with the paper to show cause, he approached the Attorney General Chamber and prostrate himself, pleading for mercy.
You go back to the question. You have explained in a very lengthy manner without addressing the first part of the question. You boleh repeat semua sekali, tapi kenapa you avoid addressing why, whether it is necessary to threaten lawyers with contempt? Okay, stop at one point dan start addressing that. Otherwise, you tak dapat markah tau. You hanya dapat markah mengulang fakta dan putusan mahkamah. Analytical part tidak ada. I have to be honest with you. You have to go back to the question, is it necessary in light of these two cases? What lessons can you learn from these two cases? What does the case of Tommy Thomas convey in terms of the in terms of whether lawyers should be threatened with the contempt court, and is that necessary? What do you derive from this case?
Tommy Thomas, who is an advocate and solicitor, it is necessary to treat him with the contempt, as he is the lawyer who is known in the line to protect the justice when he himself disobedient to the court order. It is a case where it is necessary he to be cited for the contempt of court in order for the judges to punish any discourtesy or disrespect in the legal system by anyone, either they are lawyer or not, or before the court or not.
So what is the difference between the position in the first and the second case? When you want to address, do you draw any distinction between what you can derive from the first and the second case? Apa jawapan dengan melihat kepada the conduct of lawyers in the first and the conduct of lawyers in the second, and maybe the decisions of the judges in the first and in the second? So, those are the comparison that you have to make. Faham tak?
For the first case, the lawyer is actually is not necessary to be treated by bank contempt, because Zainal Zakaria actually want to protect his client, his interest of his client, as the motion that he was filed was due to the two senior prosecutors trying to fabricate the evidence, where the prosecutor is the one, the two prosecutor were in charge in the case of his client. So if two prosecutor was fabricate the evidence, hence it is unfair to his client to has been charged with the prosecutors. So this is the first case, and it is the right of the federal court to decide where there is no contempt on the part of Zainal Zakaria. Whereas the second case, the second case.
On the second case, it was obvious that Mr. Tommy Thomas, the advocate had breached the court order and also scandalized the judges where he contend that the plaintiff uh, trying to get the judges favor in their litigation they were involved. So it was an obvious improper conduct done by the advocate.
How would you conclude, okay, based on the question just now? How would you conclude looking at the two comparisons that you made between the first and the second case? What is your conclusion answering again to whether contempt of court is necessary to be taken against lawyers? Whether you should threaten them with contempt? What is the conclusion? Kalau ada presentation, mesti ada pembuka dia punya analisa dan also your concluding remarks.
In, for the conclusion, it is a fundamental requirement of the advocates and solicitors to take all relevant legal action to protect the interests of their client in every appropriate way. Hence, the case actually causes a big impact on the operation of the rule of law in Malaysia and also Malaysian judiciary in order to have the right to enjoy the fair trial and also the ability of Malaysian advocates to present the strongest possible case in defense the clients. And also it is dangerous of leaving the law of contempt uncertain, and it is the time for the legislature to look on the law of the contempt in order to make it into the area of law in order to make the proper action to be taken by the court in order in the law of the contempt, and also for the rationale applies in order to protect the and also to protect and maintain the dignity of the judge to
Okay, I nak you firm up lagi presentation ni. Saya nak make sure bila you hantar, sebab takut affect markah nanti, whoever wants to kemas kini balik slide supaya nampak lagi padat, tidak panjang berbeza tapi padat dengan benda yang perlu. Contohnya you tidak discuss tadi what is the type of contempt that is involved. Okay, what is the rationale on the law of contempt? What are the boundaries? Okay, laid in case law. Semua tu tak ada dalam presentation. Terus discuss tulis dan saya terpaksa tanya satu-satu untuk make sure you address. Otherwise you would completely forget and ignore, which is completely akan affect you punya pemarkahan, ya. So make sure you fulfill apa yang question tu nak dalam presentation. Selain daripada dua case ni, you boleh bawa case-case yang lain juga yang menyatakan the principles involved. Okay. And you said in your concluding remarks there are uncertainties around the law on contempt, but you did not actually point out what are the uncertainties that you talk about in the end di peringkat awal. So semua ni adalah gaps that you have to address, okay? Untuk dapat markah yang baik, semua ni kena cantik dalam presentation you. Saya tak semestinya nak ulasan yang panjang, tapi kalau dalam bentuk infografik pun benda tu ada point tu, ada case tu, saya nampak dah struktur you nak jawab macam mana. Faham tak? Rather than very wordy presentation tapi tidak menyentuh menyeluruh ya, secara menyeluruh dan menggunakan kaedah yang atau approach yang baik untuk menjawab soalan ni. Faham tak yang lain? Dia punya struktur jawapan tu tak ada. Terus
Faham.
patutnya you ada apa definasi contempt dalam kes ini. What is the type of contempt involved? The law that it So saya minta you hantar balik slide, yang lain pun sama juga ya. Saya terpulang pada you lah. You nak markah yang baik, you bagi benda yang nampak sangat orang kata strategic. Strategic that means you strategize betul-betul cara menjawab dengan menggunakan struktur, dengan menggunakan prinsipal dan konsep yang betul, semua ada. Analisa yang baik, conclusion yang baik. Faham? Saya bukan suruh buat esei panjang berjela. Saya nak tengok rangka you jawab tu. Rangka tu, case tu ada dalam bentuk bullet point pun tak apa. But bila you present, you explain lah. Tak perlulah nak letak everything. Tapi tak menjawab soalan secara fundamentalnya. Okay? Kena jawab soalan tu. Bukan kita nak dengar fakta dan apa decision dari dalam dua kes tersebut. Tapi kita nak relate kes tersebut dengan persoalan utama. Do you need to threaten lawyers with contempt of court? Okay, discuss this in the light of the first and the second case. How is the first case, justified, and how is the second case you think contempt of law is needed? What are the, the gaps in the procedures for instance that you think should be rectified? Semua tu tak ada tadi tu. Ada dalam bentuk bila saya tanya tu you jawab. So benda tu daripada awal kena ada dalam slides ya. Ada soalan lain tak? Siapa yang nak present satu lagi ya? Soalan mana? Conceptual, kalau tak faham konsep tu, tak guna discuss case panjang-panjang tapi kita tak faham konsep, dia tidak boleh jawab soalan. Sebab tu bila saya ngajar tu, konsep tu saya sangat pentingkan. Kalau tidak you discuss benda tu di luar daripada konsep, which is dangerous. You appreciate the fundamental principle, konteks dia, konsep dia, boundaries dia, benda-benda asas tu, then you'll be able to, contextualize your discussion. Otherwise dia jadi very general dan kita tak tahu how to actually approach and address the question secara structurally and strategically. Untuk dapat markah yang baik, semua ni kena tahu ya. Next group siapa? TLB berapa?
Rasanya for today itu saja doktor.
Kalau belum yang saya rasa macam ada TLB Syahmi, ada satu TLB ke dua TLB yang saya cakap hari tu ya?
Untuk yang mana?
Presentation hari ni. Saya ada pesan kan?
Untuk hari ni sekejap saya check balik.
TLB1 dengan kalau tak silap saya TLB2 pun hantar recorded saja tapi belum present kan?
Oh yeah, TLB
Yeah.
1 and TLB 2 should be
Ah,
today.
okay, TLB 5 ni dia kena buat I think separate question kan, separate question. Walaupun dia dah present tapi dia kena submit separately. Betul tak?
Betul betul.
Betul. Okay, so TLB tu macam mana? Ada nak present tak? You buat soalan nombor 2, betul tak? Case review.
Yes, madam. TLB2.
Aha, ada.
Okay.
Kalau kita tak discuss dan langsung kita tak nampak macam mana ya the law on contempt operates. So kita discuss sikit lah.
Okay.
Please be concise dan begitu padatkan presentation kepada konten utama.
Okay, exercise on case review question number 2. Indeed, on the question 2, Datuk VC Judge, former Court of Appeal Judge, opined that any judge who is in the habit of turning contempt in order to control his court must be suffering from some sort of inferiority complex, is not fit to grace the bench. Discuss the above statement.
Ini case review ataupun apa boleh
Case review, madam.
saya rasa soalan ni macam tak penuh. Soalan yang penuh ni macam mana?
Di full question, madam.
Ni je question madam lagi.
Sekejap saya tengok slide saya sekejap. Okey, kita ada satu lagi soalan yang Kamal Halili punya artikel tu tak ada orang buat ya? Ada satu question number 3 yang tu siapa yang buat
Sekejap doktor, saya check balik.
The Law of Contempt article by Wijaya Lakshmi and Kamal Halili.
Kamal Halili. Oh, that one
Supposedly
is
TLB3 4.
TLB 3 and 4, but that one is on the next class, doktor.
So please remind me next class nanti tolong present lah. Kalau kita tak bincang nanti takut tak boleh jawab dalam exam pula.
Okay, alright, sure.
Okay, please proceed.
Okay, firstly, I will give the definition of contempt of court, and next is what constitute contempt of court and power to punish for contempt, and lastly, before to the case review, the reason for contempt jurisdiction. Okay, firstly, the definition of contempt of court. In the case of AG v Tong, the court held that the contempt of court is so manifold in its aspect that it will be difficult to give comprehensive definition. And also, our written law does not define the phrase of contempt of court. So from these two, we know that there are no definite or exact definition of the contempt of court. However, what constitute to the contempt of court can be reflected or explained in the case law. And as we learned before, there are 3 types of contempt of court. Firstly, contempt in the face of court. Secondly, scandalizing the court. Thirdly, sub judice comment. And in this case, highlights what constitute the contempt of court. Firstly, in the case of Lai Chen Chong against public prosecutor, The improper conduct from lawyer and client that fail to attend trial without a valid excuse considered as contempt of court. And also the interference or obstruction the court officer's work, such as official signing, also considered as contempt of court in the case of Datuk Abdullah Hisham. And in the case of Datuk Lela, the advocate and solicitor guilty of contempt in the face of court has failed to give satisfactory explanation to his client's absence. And next is the power to punish for contempt. This power is entrusted to the court to punish a person who did the contempt actions, and this power derived from the Federal Constitution and also Courts of Judicature Act, which highlight that the federal court, the court of appeal, or a high court shall have power to punish any contempt of itself. And the case of Zainul Zakaria, the contempt of court is a means that enables the court to take action to prevent or punish conduct that tends to obstruct, prejudice, or abuse the administration of justice. So, next we move to the purpose of contempt jurisdiction. In the case of Perbadanan Pembangunan Pulau Pinang, it was held that the purpose of contempt jurisdiction is intended to protect the administration of justice. And also in the case of Chia Cheng Hock, the purpose was to maintain the dignity and authority of the judge, ensure the fair trial, and also to prevent the obstruction of justice. However, there are some issues on the contempt power when the judge are too ready to use this power in order to control his court. And in one article that I found in the Malaysian Law Journal, stated that some magistrates and even some judges were apparently resorting to abuse counsel and further having to rely on the frequent invocation of their powers of holding counsel in contempt of court in order to control his court. This memorial note of the late Tan Sri Ismail also stated that if this happens more than once, the possibility are there is something fundamentally wrong with the judge. And from this, we know that there are some situations when the judge used this power to control his court, and this power should be used sparingly and must be used when it is necessary only. However, in some situations when the judge used this power too much in order to control his court. So next we move to the case review.
For the case review, we refer to the case of PCP Construction Syndrome Berhad against Lead Modulation Syndrome Berhad. And this is the case of last year in a federal court. So what happened in this case is the PCP Construction Syndrome Berhad and Lead Modulation Syndrome Berhad both involved in a suit before the High Court over a claim for compensation. And then PCP Construction had made an appeal to the Court of Appeal against the High Court decision. However, the majority of the Court of Appeal decided to dismiss the appeal, and the dissenting judgment in about 17 paragraphs has put it into the judgment, had made certain remarks which detrimental pronouncement against Asian International Arbitration Center, which is now KLRCA. And even though the AIAC was never a party to the litigation, nor even mentioned in the pleadings of the party, the dissenting judgment had called for a copy to be forwarded to the Malaysian Anti-Corruption and also to the police department to to investigate and take any necessary action over the the uh, the AIAC. And then the PCP made an application for leave to appeal to the federal courts against the majority court of appeal decision. And AIAC agreed or angry or upset by the comments that were made by the judges against them in the dissenting judgment, therefore made an application to intervene in the leave application and have the offending paragraph expunged from the record. And then Arun Kasi had made various remarks about the decision, which appeared in 2 articles, where Arun Kasi said that my apology. Where Arun Kasi has Arun Kasi has made 2 remarks that have been offended the judicial institution, and therefore the issue arises from Arun Kasi remark had created a specific issue before this court whether Arun Kasi had committed the offence, the criminal contempt in scandalizing contempt in providing the material for the 2 articles published by Aliran on 16 February and also in 22 February in 2019. So the principles arise from this issue, this case. They are the principles have been referred to the Article 126 of the Federal Constitution, as well as Section 13 of the Courts of Judicature Act and Order 52 of the Rules of Court 2012. And the things and the points that need to be present in order to sustain the conviction for the scandalizing contempt is the court had to look whether the statement in question poses a real risk to real risk that would undermining public confidence in the administration of justice, whether the respondent had really intended to publish the statement in question, and lastly, most importantly, whether the respondent had not done to pursuant to fair criticism. And the federal judge had made several reference to the case of R.Y. Pang against Attorney General in 2016 on making on making the judgment. And the judgment were made by Federal Court Judge Tan Sri Ramli Ali, as well as 4 other members panel, found that although they have been considering the bar opinion on whether to really punish them with such punish them with a sentence of imprisonment or fine. However, the federal judge found that the statements that were made by Arun Kasi, the lawyer, were too remote, that it causes that it detrimenting the trial and also the sanctity of jurisdictional institution. Plus, the fact that Arun Kasi has not made any formal apology to the court unreservedly, that causes the court to further with the sentence of imprisonment of 30 days and fine of 40,000 ringgit over the fact of his being guilty for the contempt of the court. And that was the first cases of the case review. And the next case will be further by the next member of our group, Ms. Najwa.
Next, I present about the case Attorney General Malaysia and Manjit Singh Dhilan. Sorry. Okay. Fact of the case in this case, the respondent made a various accusation and allegation to the appellant in the aforesaid affidavit against the Lord President. Lord President, which is the appellant. And then there are many accusations have in the aforesaid affidavit, which in the paragraph 7, the respondent had alleged the appellant did commit contempt of the Supreme Court by attempting to prevent, frustrate and interfere in the proceeding. And next, in the paragraph 9, the respondent against accused the appellant said that the appellant has abused his official position to protect his own personal interests. And then in the paragraph 7, subparagraph C, the respondent said the conduct of the Lord President is affront to the dignity and impartiality of the court. And lastly, the respondent said the Lord President has described amount to exercise of power, improper motive and interfering with the court of justice. Then, issue in this case is whether the allegation made by the respondent, i.e. Manjit Singh, to the appellant, Lord President, is an offence of scandalising the court as stated in Section 3 of the Civil Law Act and Article 126 of the Federal Constitution. There are various principles have in this case. First, Section 3 of the Civil Law Act, Article 10, Article 126 and Section 13 of the Court of Judicature Act. First of all, in the High Court, the court allow to punish the respondent because his improper action to allege the respondent to allege the appellant to make that scandalizing the court. But the respondent appeal to the Court of Appeal said that the respondent has not crossed the line of scandalizing the court because he just made a mere abuse of a judge, which defamatory or mere abuse is not contempt of court. But we rely on the many various of decision from the many case and judge, which in the first case, R and Gray, when the Lord Russia said that any act done or writing published calculated to bring of court or judge into contempt, which is have lower his authority, is regarded as contempt of court, which scandalizing the court. And the Lord Russia said judge and court are allowed to open criticism, which means people can critique the judge and court, which is in a good faith and not attempting to personal sclerosis or personal matter. Then the next Muhammad Azmi Supreme Court Judge say in Malaysia the need to protect the dignity and integrity of the Supreme Court and the High Court is recognised by Article 126 of the Federal Constitution and also Section 13 of the Court of Judicature, so that other people can allege or accuse the judge and court because to lower their integrity. That.
Muhammad Azmi judge said, also said, a criticism is allowed, but within the limits of reasonable courtesy and good faith. There are many cases which related to the scandalizing the court. But the most important is in Pakistan, on the Article 123 of the Constitution said, provide that Supreme Court and the High Court shall have power to punish any person who scandalize the court or otherwise does anything which tend to bring the court or a judge of the court into hatred, ridicule or contempt. So next, there are elements must be present to convict for scandalizing the court. First, a person who charged with contempt of court must be proved that he's guilty, must be proved beyond reasonable doubt. And second, there is mens rea and not critiques the court and judge in a good faith and of the judge of the court. And lastly, the communication was offensive and amounted to contempt of court by scandalizing it. Lastly, for the judgment, in the Supreme Court, a lot of Harun Hashim Muhammad Yusuf and Gun Chit Tun Supreme Court judge said that the respondent, the allegation made by the respondent are regarded as stated in Section 3 Civil Law Act, which applicable in Malaysia jurisdiction. And second, the allegation are defamatory attack on his reputation, mean on appellant reputation, which could be considered to be abusive of the judge. And C, the respondent was guilty for contempt of court and have fined 25,000 and 3 months in prison to him. I think that's all. That's the end of the slide.
Okay, who did the presentation just now? First, I think is Fatiha. No, Fatiha, right?
Yes, Fatiha.
Yes. Yes, I did.
Second, siapa?
Nur Asmida.
Nur?
Asmida.
Nur
Asmida.
Asmida.
Third?
Wan Najwa.
Okay, please write down the name of the presenters on the slides, okay? So it's good that you you know that the more focus should be on scandalizing the court, because I think not to forget that other types of contempt may also be relevant here, but I think your focus is more on scandalizing the court, the cases that you discussed just now. Are more in the context of scurrilous attack against judges, right?
Yes.
Okay. But if you look at it doesn't suggest that that you should actually focus on cases of scandalizing only. Right. So it's very tricky sometimes, but I would rather start with an overview of the different types. I think you did that, and then maybe one case on scandalizing and another case on maybe and maybe contempt in the face of the court, probably, which is a bit different, but can actually trigger a judge to immediately conduct a summary trial. For instance, the case of Zainul Zakaria, for instance. If you have a recent case other than Zainul, I think it would be good to compare these two types of contempt. Okay. And don't forget to also highlight the balance that they have to strike between that is needed between freedom of expression and also the duty to maintain the court's dignity and impartiality. All right, the duty to respect and ensure dignity and impartiality of the court. So there is a need between the interests in the first as well as in the second. And I think you did touch on freedom of expression when you mentioned about fair comment. All right, in the first case, it was not the writings were not within the ambit of fair comment, and therefore there was no privilege or exception to that. Uh,
Yes.
in that context. Alright, so yang lain kena faham ya, what I'm trying to comment on here is how you can improve your answers, right?
Mhm.
Bila kita tengok jawapan presentation tadi, firstly mereka fokus lebih kepada the type of content which is called scandalizing. And then my response is that you do not necessarily have to focus entirely on scandalizing. You boleh juga discuss something that is related to that, which is contempt in the face, for instance, ya.
Mhm.
Kemudian you should discuss the balance that has to be struck between hak seseorang terhadap freedom of expression. You cannot deny the right in Article 10 of the Federal Constitution that give everybody the right to say things they want to say, as long as they do not cross the whatever caveats, like macam fair comment is still something that can rescue a person from being being guilty of contempt. Okay, so satu lagi, sama ada it is a personal attack. Okay, that is also cases that discuss about the boundary between maintaining your reasonable courtesy and good faith and crossing the line when you make personal attack against a certain judge or judges, ya. So ini adalah antara points yang you boleh discuss dan elaborate. Okay. So is it injurious to the judge or injurious personally? Is it damaging to the administration of justice, or is it damaging to the personal reputation of the particular judge? So the law of contempt, I think, tends to protect the latter, which is the administration of justice as a whole, rather than the personal reputation of a particular judge. Okay, but you have to tengoklah case macam mana dia explain about this.
Okay.
So I think that's all that I wanted to comment, unless other students might want to add on.
Doctor.
Kejap ya, the offence of scandalizing the court to prevent scurrilous abuse or attacks upon the authority and impartiality of the judiciary as a whole, okay, or of a judge pun ada, but rather it is the protection is in order to maintain public confidence in the administration, but not to maintain just the reputation of a particular person. Itu adalah the idea behind contempt. It is not to protect the feelings of a particular judge, for instance, but rather to maintain confidence in the entire system. So kalau you belittle the reputation of a judge, and because of that it can actually undermine public confidence in the system, then it is justified to to invoke contempt. If it is only because you feel overly sensitive that your your judgment has been criticized and whatnot, etc. So that is a bit, contentious there. So itu adalah antara kontroversi lah yang selalu berlaku. Ada apa lagi nak tambah tak? So please baca articles ya, and selain daripada cases kita boleh refer kepada articles lah, ulasan mengenai tajuk ni. Ada juga orang yang buat thesis pasal tajuk ni ya. Kalau ada apa-apa lagi yang lain?
Saya tak ada doktor. Macam ada yang kata.
Ada soalan?
Sorry madam.
Ya.
Saya mungkin bukan berkenaan soalan presentation, tapi saya nak minta consideration daripada madam berkenaan dengan presentation video dengan poster tadi yang awal tadi.
Okay.
Sebab ianya melibatkan kuliah kan, satu kuliah hampir 40 lebih orang. Jadinya untuk discuss dan itu agak payahlah, melainkan satu TLB tu mungkin berkemungkinan boleh diusahakan, tapi seramai 45 orang atau lebih itu mungkin agak sukar lah untuk kita.
Saya sebenarnya nak cari apa yang memudahkan you all, tapi if you think that you susah untuk collaborate dalam big numbers, then kita boleh ubah kepada each TLB untuk buat masing-masing punya ni lah. Depends on yang lain juga. Macam mana you rasa?
Yang lain semua setuju doktor.
Setuju yang mana? Setuju dengan untuk buat
setuju untuk kita buat by TLB.
You buat TLB, okey, tak apa. Nanti saya ubah balik dalam, tak ada masalah. Asalkan saya tak nak macam terlampau membebankan you all sebenarnya. But if you think it is easier for you to work in smaller groups, then I'm more than happy. Yeah.
Okay.
Ada lagi tak?
Madam. Sorry madam.
No problem. Kalau ada apa-apa, just let me know, because I'm willing to listen. It's just that I do not want to put extra burden dalam keadaan sekarang.
Faham. Thank you doktor.
Faham madam. Thank you doktor.
Ada apa-apa lagi tak? Kalau tak ada apa-apa, macam itulah, revise balik presentation. Okay, make sure kita boleh menjawab persoalan yang diajukan. Bukan sekadar discuss tapi lupa untuk address the core question. Ya. Saya cuma bagi guidelines how to jawab. It depends on your research. Tidak ada jawapan yang fix, katakan A, B, C. Semuanya bergantung pada case yang you guna, articles yang you rujuk. But all in all, it has to be structured and it has to be strategic. That means kena susun supaya menjawab objektif soalan tu ya. Tak ada apa-apa lagi, itu saja. Nanti saya akan upload mana yang berkenaan lah. Right, thank you for joining our session today. Saya dah download attendance towards the end, so make sure do not leave the session too early because your name might not be in the list. Bila kita download attendance tu, ada senarai bila you log in, bila you log out and log in balik, semua ada detail lah. So make sure you stay in the session throughout lah. Okay.
Okay.
So, untuk hari ni kita akan kira attendance sekali dengan tutorial lah. Kita discuss tutorial lah.
Right.
Okay, thank you very much. Assalamualaikum ya.
Thank you doktor. Terima kasih.
Thank you madam.
Terima kasih banyak doktor.
Thank you madam.
Guys, attendance dah kira ambil
Dah.